Well argued. The next case is HJH versus Volusia County. And we'll take a break after this case. How much time would you like for rebuttal?
5 minutes, Your Honor.
All right, you may proceed.
May it please the court, my name is Martin Auerbach. I'm here for HJH LLC. And although the issues have been briefed by both sides, there's really only one issue in this appeal, and that is, where is the western boundary of the public's right to use the beach area as far as the beachfront?
The property, the lots in question, were they north or south of the property platted in the 1889?
South of it. We're at the complete opposite end from the property in Reynolds.
The 1889 plat, that's the only one with an express dedication, correct?
That's correct. However, each of these plats is ultimately an overlay of the others. So they all, and that was part of the court's basis for finding that the dedication, that combined with an agreement from 1917, which regardless of whether the agreement was admissible, not admissible, whatever, doesn't go to the court's finding, there's no support enough for the court's finding that the western boundary goes to the 450-foot lot line, as it's being called.
The 1917 agreement, if anything, talked about the size of the lot or the depth of the lots?
It simply said something to the effect that it would be platted in a similar fashion.
But if you took it to what you would agree, perhaps, is its furthest extreme, it dealt with the lot size, it didn't deal with the dedication to the public.
That's correct. Yeah.
Okay.
But even so, if it did deal with the dedication, then it militates against the court's finding of moving the boundary westward 150 feet into the property. It would go to the eastern foot of the sand dunes, as is already in the FC Austin plat.
Which is the 1889 plot, and that's the only one with the express dedication.
That's correct.
From the dedication is from the eastern foot of the sand dune seaward, correct?
That's
to
correct.
The Atlantic Ocean?
That's correct. And on the 1889 plat, it's called Beach Street. On our plat, all it says is Ocean Beach.
Right. And the trial court found that those were the same geographic area, correct?
Yeah, they basically found it was an overlay and that Ocean Beach was a continuation of Beach Street. However, and the crux of the issue is there was absolutely no evidence in terms of a dedication that the boundary line should be anywhere other than the eastern foot of the dunes. In fact, as we pointed out in the brief, the only evidence that the court appeared to rely upon was the testimony of the county's expert witness, Jamie Seaman, and she basically advanced three reasons why the 150-foot line should be the boundary. The first was that if it weren't, then it subsequently would have resulted in a hiatus because the Austins would still have owned the land between the dunes and the 150-foot lot line, which has nothing to do with what the Austins' intent was at the time.
In terms of the dedication?
Yes, at the time of dedication, and for dedication you have to look at the present intent of the plattor.
If we go back to the 1889 plat, those lots on the ocean front were 150 foot, is that right?
That's correct, yeah.
So if you apply that logic, there's still a gap, if you will, between the east end of those 150-foot lots and the dedication to the public, wasn't there?
Yes, as a matter of fact, in Reynolds, and we included in our brief, there's a sketch that this court put in there where they actually show area in dispute, and it goes from the water line up to the dunes, and then there's a gap between the lot lines and the rest of the land.
What's west of the dedicated line, whatever that might be, is of no concern to Volusia County, is it?
Apparently it is.
I mean, legally, they're not claiming a right to anything west of what the dedicated line is.
No, wherever that is.
Right, they're just arguing about, they're saying because it's 150-foot lots, therefore the dedication moves further westward.
That's correct. They're saying that it should go to that, but the only rationale, they said, as I said, was Ms. Seaman's testimony. The second point that she raised was that she said most of the time, not all the time, but most of the time, a boundary is not a monument that can move over time, which really isn't correct because there are a lot of monuments that move over time.
Here, the state's right depends on where the mean high water line is or the average high tide line is, doesn't it?
Exactly, not to mention all the boundary lines that are based on rivers and lakes and things like that. The third reason, which Mr. Siemens gave, was that it would be preferable to the county to have a static line, to have a fixed point, so they know where the public's rights begin and end, which is understandable from a governmental perspective, but once again, has nothing to do with the determination of what the Plattor's intent was at the time. Also, just to mention, even regarding that hiatus argument, that's not an issue because the trial court determined that HJH owns that property based upon the Marketable Record Title Act.
Right.
Now, if the property line or the boundary line of it were based upon the doctrine of common or customary usage, there's no question that the boundary line would be the permanent line of vegetation, which is basically the same as the dunes. Even the court found that in its order. It said that in the alternative, it was finding customary usage applied, in which case it would be the permanent line of vegetation, and that his court said it moves over time. The leap of logic that the trial court made was it cited Reynolds and said that Reynolds stands for the proposition that the boundary line of the dedication goes to the 150-foot lot line, and it's not apparent where the trial court came up with that conclusion.
There is a sentence in the Reynolds case that says everything, that the dedication was east of the eastern boundary of the lots, but it also has, as you said, the diagram which shows the lots, the dunes, and then east of the dunes, this is the area in dispute, and also describes in the opinion in Reynolds that the area in dispute is east of the lots, east of the dunes, but, west of the high tide mark.
Yeah, and that was addressed the county raised that in their answer brief. We responded to that in the reply brief by saying that there's more specific language in the Reynolds opinion, and that the only thing that was being considered in Reynolds was the land between the dunes and the water, basically the water line, so.
It couldn't really be clearer when you look at that picture, could it?
Excuse me, Your Honor?
It couldn't be any more clear when you look at the diagram in the Reynolds opinion what's in dispute.
That's correct, and that's why we included it in our brief. It's clear that what this court was talking about was when it said Beach Street in that plat, and it said 300 to 400 feet from the foot of the dunes, and unfortunately what's apparently happening is, to the extent that the trial court and the county were relying upon the 1889 plats to incorporate that, it comes down to their picking and choosing which parts they are willing to infer into the 1917 plat.
Well, here, the trial court says in the order that, I'll just quote, if that were true in 1889, referring to the plat, it was surely true in 1917 regarding the intent to dedicate. Then the Ocean Beach in the 1917 plat, by overlaying the same area occupied by Beach Street in the 1889 plats and extending south to 13th Street, reflects the intent to dedicate to the public all the lands east of the 150-foot lots.
And that,
And before that, he talked about the fact that, it'd been used by the public and all of that, so.
well, the use by the public only goes to customary use. That doesn't go to common law dedication.
Right.
But
He talks about that later on in the opinion, in the order as well, so, but what about that finding? What is your response to the fact that, there was this overlaying in the 1917 plat, and that constitutes clear evidence of intent to dedicate?
well, it does require you to go outside the 1917 plat to determine what the intent was. But regardless, our position on it is that even if the court was correct on that, even if that you can look at the entire thing in the history, and even the 1917 agreement, that doesn't explain using this 150-foot lot line as the boundary as opposed to the foot of the dunes. And that's the point I was making when I said that the leap of logic that the court made, because although the court says in that quote that it extends a 150-foot lot line, it's not apparent where the court came up with that conclusion. It just pulled it kind of out of thin air.
The description of Beach Street for its western boundary was the east foot of the dunes.
That's correct.
And I suppose your clients would be happy if that were still the western boundary of the dedicated property.
Exactly. This case is not about whether the public has a right to use the soft sands or any of that. We readily concede that, whether it's by dedication or customary use.
It's conceded, and the court found below that your clients own the 300-foot depth lots.
That's correct. So, I'll be honest, I've covered my points, Your Honor. I'll reserve what I have left.
Okay.
Good morning, may it please the court. Assistant County Attorney Mary Jolly, along with Deputy County Attorney Larry Smith on behalf of Volusia County. With regard to appellant's argument, there's several things that I'd like to address, and first and foremost, the notion of the public usage of the beach doesn't just go to customary use, it also goes to acceptance of the dedication. So I just wanted to clarify that evidence of...
The only express dedication is in the 1889 plat, which does not even cover this particular property, correct?
I'm not going to say that's 100% correct. First, I think what we need...
1889 plat, if you look at it, does not include Block 25.
Oh, I agree, I concur.
I mean, geographically, that plat.
Correct. It runs from 1st to 22nd, and the 9th...
The only express dedication is from the eastern foot of the dune seaward, correct?
I disagree with that, Your Honor.
What does it say exactly?
The language of the one of three, there's three 1889 plats, but before I address that, we have to start with the 1917 plat.
No.
Okay. Well...
We're going to start with the 1889 plat, and the language there for Beach Street is, all of the beach from the east foot of the sand dune to the low water mark is hereby dedicated to the public for a highway.
Correct.
Okay, and there's no other express language of dedication anywhere?
The three plats provide for express language dedicating to the public, express saying those words are on those three plats. The one plat, one of the three Austin plats, the FC Austin plat, has that additional 300 to 400 foot language. The other two do not. My concern with appellant's argument is...
But in terms of giving a western boundary, the only western boundary given in the 1889 plat is the east foot of the dune.
I disagree with that, Your Honor.
Tell me where else it said some other eastern or other western boundary in the 1889 plat.
This court found in Reynolds that the area of dedication comes from the lot line. The Reynolds opinion...
Did you look at the diagram in Reynolds?
I did. And may I explain? Sure, and the area, I think what you have to do is look at the Reynolds opinion as a whole. At the outset of the opinion, in a footnote, they do a rough sketch of topography, and I'll be in quite candor, Your Honor, the first time that rough sketch was ever seen is when this opinion came out. I was not counsel of record in that case, but it's my understanding that it was not in the record on appeal. So what Judge Sharp does at the outset of the opinion is say that the area in dispute of the lawsuit is the sandy beach seaward of the respective lot owner's property. That's at the outset at 1187. And that drawing is a footnote at the outset of the opinion. But when you go through the analysis of the Reynolds opinion, and what the ultimate holding of the Reynolds opinion is, there's no mention of the disputed area, there's no mention of the sandy beach. The holding, which I believe you alluded to during Appellant's argument, was that the examiner of the Austin Plat as a whole, not just the plat itself, not that drawing, would manifest the clear intent of the dedicator that the land between the lots and the ocean be used for the many purposes customary incident.
At page 1187 of the opinion, it said the county filed a declaratory judgment suit naming the lot owners as defendants. It, being the county, being you, sought clarification of its powers to regulate and control the public use of the sandy beach area seaward of the permanent vegetation line, which is consistent with the sketch, extending to the mean high tide watermark pursuant to the county's home rule charter and unified beach code. So the clarification the county sought in Reynolds was its authority to regulate seaward of the permanent vegetation line. So whether or not this is a beautiful drawing or a great sketch, it says, it does indeed accurately define what, according to the court, was what the county sought clarification for.
And I'm saying that this court found that that clarification landed the line of dedication at the lot line based upon its holding at the end of the opinion. At 1190, 3 times, Judge Sharp talks about the language of the lots and what future purchasers of the lots needed to know what was dedicated to the public. That language is clear in that sentence I began to read regarding the lot lines. And then further down on 1190, the unreserved language of the dedication reflects his intent that it be so used used in the future by the purchasers of all lots in the subject and in the public. And then it goes on to talk about the lot lines. And I think what I disagree with Appellant's argument is that there was some sort of leap here from the Austin Plats to the conclusion that Judge Rouse made in this case. There wasn't a leap. The 1917 Plat on its face has the plain language of Ocean Beach. There's no additional language that was included in the 1899 Plats. And I think what that does is give this court confidence that the actual area of dedication comes from the lot line, because the 1917 Plat clarified that. And I think...
But the Ocean Beach was found by the trial court in this case to be a duplicate of Beach Street, correct?
Well, sure, that it overlays the area of Beach Street.
Not overlays and spills over, though. It overlays, it's a duplicate.
Well, but the Platters took in 1917, what they did when they created the 1917 Plat is they took property south of 22nd Avenue and platted that pursuant to that contract for deed. And what they did...
The lots in the 1889 Plat, the oceanfront lots, they were 150 feet deep as well.
Correct. And
the dedication doesn't say from the east end of our lots to the sea, it says from the east foot of the dune to the sea.
I'm saying, I think Reynolds holds that it's from the east 100-foot lot line of the, that's what the holding in Reynolds is. Reynolds does not say, I'm sorry, go ahead.
It says from the east side of the lot, but there's a lot to the east. There are many things to the east.
Reynolds holds that the line of dedication runs from the lot line eastward. In the 1917 Plat, I think this court can be comfortable in its conclusion affirming the trial judge's ruling in that regard for the reasons I've stated already, but also explicit in the 1917 Plat, again, are these lot dimensions, that they be 50 by 100 feet. There's a reference specifically on the Plat at record 3881 regarding the lot dimensions, and that then the lots that flowed and were sold and conveyed throughout that time period were all at those dimensions, and that based upon...
It went from 150 to 300 to the high tide mark.
But the problem with the 1925 plat, Judge Edwards, is that you can't plat what you don't own. And they took title pursuant to the 1917
You're
plat.
asking now, though, you're asking, we want west of the foot of the dune.
Correct. We want it from the dedication, the eastern lot line is the area of public dedication.
Public dedication couldn't be clearer, and when you look at Reynolds at that picture, I mean, are we to ignore the picture?
I think, not to ignore it, obviously, but
You can't do both. You can't take it into account and ignore it. It says in the words of the court, it says the part in question is vegetation seaward, the picture is vegetation seaward, but you're saying no.
I'm saying that's a rough sketch as it's described in a footnote. I'm saying that the clear language at the end of Reynolds, the written language is that the area of dedication has to be based upon the lot lines. I think Reynolds is clear on that. And in this case, the 1917 plat clarifies any cloudiness with regard to that sketch because none of that descriptive language is on the 1917 plat.
The 1945 and 1925 show the end of the plat, the end of the land in the Atlantic Ocean with no beach.
But again, that's still the dedications established by virtue of the 1917 plat on those southern blocks.
1917 plat because it says Ocean Beach?
Correct. Correct.
Did they dedicate Atlantic Ocean to?
They dedicated the portion, well, the United States government owns Atlantic, they own out into the ocean, but the area is subject to the public's use.
Description. This is the beach, this is the ocean.
They were United States lots at the time they were conveyed to the Coronado Beach Company in 1917. They took them then. It's further our position that when what we did below and what the county did and what the judge found, and again, this is coming, I remind the court, I'd be remiss in not reminding that the standard review in this case, this was a bench trial. The factual findings come before this court with a presumption of correctness. What Judge Rouse did, and Judge Rouse has heard, this I think was the third beach trial he had heard. He's probably, at the time, he's retired, but was very experienced in this area. He looked at all of the totality of the evidence regarding the contract or deed flowing from the contracted deed, all of the lots sold pursuant to that deed, and based upon that, he made several findings to support the conclusion that that was an offer of dedication in the 1917 plat. He relied on the 11 oceanfront lots that were conveyed during that time. The fact that when Fuquay and Rogers platted the 1925 plat, they even sold lots at the 50 by 100 foot dimensions in that short area of 27th to 30th, which they didn't replat when they did the 1925 plat.
The 1925 plat doesn't show beach at all, does it?
Right, but they're trying, and they tried to take land they couldn't have. They tried to take what they didn't own, because all the lots were conveyed at 50 by 150 feet, not 50 by 300. And the 1925 plat...
Just because the people who bought the lots don't own the extra, whatever it is, 50 feet, 100 feet, 150 feet, how does that then say the county does?
You can't...
The county has the right to it.
Because it's our position that Ocean Beach constituted an offer of dedication, and that dedication has been accepted by the public's use. All of the evidence we presented to support of that was not refuted. And in fact, their surveyor, Mr. Kruger, agreed that the Ocean Beach in the 1917 platted lots at 50 by 150 feet. So it's our position...
You're primarily relying on, I guess, the part that I quoted before, the Ocean Beach in the 1917 plat, by overlaying the same area occupied by Beach Street in the 1889 plats and extending south to 13th Street reflects the intent to dedicate the public all the land east of the 150-foot lots.
I rely on, that finding, I think, is supported by the evidence, Judge Soraya, in addition to the paragraph following it, paragraph 14, bolsters that finding where Judge Rouse points to the evidence that people took the lots.
With knowledge of that.
Correct. That's our position.
Is your position that's an express dedication?
Yes. Yes, and then it was accepted by the public. The use of the public of that dedication is unrefuted. In footnote 3, I believe, of the order, Judge Judge Rouse goes through the overwhelming evidence that we presented that went unrefuted regarding the public's use of the beach, which is evidence of the acceptance of the dedication. And again, we reiterate to the court that the 1917 plat actually gives this court clarity on where the area of dedication runs, because that language, because of the way it was platted, and it sets the lot dimensions, and it demonstrates the area of what was intended to be dedicated to the public. And it's our position that the final judgment takes all of the evidence that was unrefuted at trial and reaches the correct conclusion that the 1917 plat did create a dedication to the public eastward from 150 feet. It's our position that those findings were supported by overwhelming evidence and that the law supports his conclusion.
You put in the 1917 agreement for deed?
Correct.
Over objection from the landowners?
Correct.
As to hearsay and relevance?
Correct.
You said that it was not offered to prove the truth of the matter asserted?
Correct.
If it was not offered to prove the truth, of what relevance could it have been?
It's relevant to show why the 1917 plat was done in the first place. That's my argument for why it would not be considered hearsay. It wasn't for the truth of the matter asserted in terms of the contents of it, but to show...
You were using that to say it proves that the lots were to be laid out at 150 feet.
Well, I can move to the alternative argument that it's properly admitted as a hearsay document, and from that flowed the 1917 plat. Appellants come forward with no argument to refute the admissibility of that evidence based upon what I argued in my answer brief. Unless the court has no other questions, I'd ask you to affirm the final judgment in all respects. Thank you.
Excuse me. Although we disagree that the public's use would expand the original dedication beyond the intent of the plat, or it might give rise to other arguments, adverse possession, prescription, or even customary use if there were evidence sufficient for that. In fact, as we point out in footnote 2 on page 14 of our initial brief, when HJH bought its property on either side of it was developed within that 150 feet that we're talking about here. And the county, it was only in 2006 that the county has adopted this position. Prior to that time, people were building in there, and there were aerials from the trial showing HJH's property with properties on the other side with improvements built right into it. So even if you were going to take a look at public use in terms of a dedication, as opposed, which, as we'd say, is inappropriate, the evidence would be that the public use was not within that 150 feet to the extent that you would even need for customary usage. And I think it's apparent from the court's questions, but I would just reiterate that the county relies heavily upon the general language in Reynolds where the court said, or this court said, examination of the Austin brackets 1889 plat as a whole manifests the clear intent of the dedicator that the land between the lots and the ocean be used for many purposes customarily incident to the use of a beach at that time. That's general language. However, as we point out in the next paragraph of our brief on page 9, the court further went to say that the land between the lots and the ocean that it determined was dedicated in the 1889 plat as follows, and the quote is, "The area in dispute in this lawsuit is the sandy beach seaward of the respective lot owners' properties, west of the mean high water tide line of the Atlantic Ocean, and east of the permanent vegetation line which runs along the dunes." There's no question as to what Reynolds was considering, what Reynolds held, and as I said before, in effect, what the county is doing, at least since 2006, is trying to find a dedication in the words Ocean Beach by looking to the 1889 plats, but, as I said, picking and choosing which parts.
That the 1917 plat overlays the same area and then includes the Ocean Beach and the other language. So that's basically what they're saying, isn't it?
Yeah, that it,
You're saying that the 1917 plat really doesn't purport to dedicate anything, right?
well, that was one of our arguments, that it should be a customary use rather than express dedication, but our other argument is, even if you find an express dedication, and even if you rely upon the 1889 plat, and even if you look at the 1917 agreement, nothing in there gives any evidence of the lot line being other than, the western boundary of the dedication being any place other than as established in Reynolds. Thank you.
All right, we will take a brief recess and ask the attorneys if they wish to join us in the Lawyers Lounge.